Good afternoon, everybody. Oh, no, that's not going to do. Good afternoon, everybody. So much better. Welcome. For those of you who don't know me, I'm Horace Anderson, the Dean here at the Elisabeth Haub School of Law at Pace University. And I'm thrilled to gather together in person with you for this really special event, the James D. Hopkins Memorial Lecture. The title of James D. Hopkins Professor of Law is awarded to a member of our faculty for a 2-year term in recognition of outstanding scholarship and teaching. It's one of the most significant faculty honors at the law school, and it was established with contributions from alumni and members of the legal community in honor of Judge James D. Hopkins, who was interim dean of the law school from 1982 to 1983. For those of you who don't already know, I'm thrilled to announce to you that Professor Leslie Garfield Tenzer is the James D. Hopkins Professor. She was named to that post in 2019. Of course, a lot of stuff happened in 2020 and the beginning of 2021. So we are now finally hearing from her in the form of her Hopkins lecture. I'm going to tell you a few things about Professor Tenzer, and then I'm going to let her come to the podium. Professor Tenzer's scholarship and teaching bridge the worlds of theory and practice and have a particular focus on regulating conduct in the digital age. And I actually talked to some people about the lecture today and described social media, non-lawyers, social media and the common law as being almost about technology versus tradition. And a lot of Professor Tenzer's work explores that tension. She teaches here, as many of you know, teaches and writes in the areas of commercial law, including contracts and sales, criminal law, torts, and social media law. She is also the host of Law to Fact, a widely popular podcast for law students, and I've had a couple of cameos on Law to Fact, really the most important things on my resume. She is the recipient of numerous awards here at the law school, including the Ottinger Prize for Faculty Achievement, which she won twice, the Goettel Prize for Faculty Scholarship, and the Professor of the Year, Teacher of the Year Award, which she won back in 2014. She frequently works with lawyers, judges, educators, students, law graduates, and others to help improve the communication and administration of justice, especially, as I said, as our understanding of law intersects with our understanding of the digital age. Most importantly, I count her as a friend, colleague, and sometime teaching collaborator, and she has saved my patootie on more than one occasion in terms of sort of helping me through teaching situations and exam design situations. So she has a very special place in my heart. And now I'm pleased to welcome Professor Tenzer to the podium to deliver the 2021 Hopkins Memorial Lecture.
Thank you. It's nice when your dean is also a friend. So thank you very much for those wonderful comments. Couple programming notes first. In compliance with the PACE COVID Task Force and the New York State Guideline for Media Production, I am allowed to take off my mask, you are not. And during questions and answer, I will put it back on. I did test negative this morning. Also, those of you who listen to podcasts know there's always a warning ahead of time when there's words that are not appropriate. We will have inappropriate words at our lecture. So just, warning if they bother you. So as Dean Anderson pointed out, today I'm going to talk about judicial and legislative responses to social media. Way back when social media became a thing, everyone said there's got to be laws for just social media, like we have criminal law, like we have torts law, like we have tax law. And so I began looking at whether courts and legislatures were actually setting aside certain rules of law for social media. And I found out they weren't. In fact, most courts that decide social media wrongs reach way back into pre-social media situations to decide how to resolve social media harms. And so what I want to do today is talk to you a little bit about my work. I'll start with a brief introduction of my thing working. There you go. and it's not working. See, technology and social media just never work. Okay, there you go. And that's not working either. Excuse me 1 second. We've tried this all out beforehand. Where is my Tony when handing him? Okay. I don't know why it's not working, Tony, but oh, there, now it is. Okay, so that's the first laugh. I'll get another one. Anyway, I'm going to present my discussion in 3 parts. First, I'll talk about the history of social media. Second, I'll talk about social media wrongs and the law courts use to resolve them. And finally, I'm going to talk about the benefits and the burdens of using precedent. Let me start with telling you a little bit about social media. Social media is technology that connects people. So social media started in 1996, about when some of you were born, maybe even before some of you were born. And prior to that, there was a very famous Broadway show and movie called 6 Degrees of Separation. It starred Will Smith in the movie. And the idea was everyone was connected by 6 degrees. And so the very first social media app, or social media website, I should say, was called 6 Degrees. And the idea was that we could connect anyone by 6 degrees. So let's play. We can connect Professor Crawford to Ruth Bader Ginsburg. Professor Crawford teaches with Professor Waldman. Professor Waldman runs the Federal Judicial's Honor Program with one of our students, Mary Duty. When Mary Duty was in the Federal Judicial Honors Program, she clerked for Justice Sotomayor, who sat on the bench with Ruth Bader Ginsburg. We have now connected everybody. Now, a lot of you know 6 Degrees of Separation, and a lot of you have heard about 6 Degrees of Kevin Bacon. So let's just play that really quickly. Kevin Bacon was in a movie with Emma Stone called Crazy Stupid Love. Emma Stone was in a movie with Betsy Adam called An Invisible Man. And Betsy Adam was in Larchmont the movie with me. All right. So those of you who had the under over that I talk about myself within 3 minutes, you won. I'm done talking about myself. My students know I'm my favorite topic. Anyway, 6 Degrees of Separation 6 degrees, I should say, did not work. And the reason it didn't work was that not enough people were on the internet. The internet really came to being in 1983, and enough people hadn't joined for it to really make a difference. But in 2002, LinkedIn made it, and as we know, we still have that. Facebook came along in 2004, Twitter in 2006, Instagram in 2010, Snapchat in 2011, and TikTok in 2016. There are also Friendster. I don't know if anyone remembers that. Friendster was offered $30 million from Google, and they said no more Friendster, bad decision. And there was MySpace and even Vine, which some of you may know. I think that morphed into TikTok. Now, the reason things were able to proliferate was because at the same time in 1996, Congress adopted the Communications Decency Act. The Communications Decency Act was an act that was designed to prevent people from seeing child pornography on the internet. As you can imagine, child pornography was rampant, and so Congress passed an exhaustive act that regulated child pornography. 2 congressmen slipped in this tiny little provision called Section 230, and Section 230 said, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another informant content provider. 26 words that changed the internet. Now, the entire Communications Decency Act, except for Section 230, was found unconstitutional. So the regulation designed to prevent child pornography was found unconstitutional because it also regulated the ability to see adult pornography, but the CDA survived. And the CDA talks about internet active computer services, which can be AOL, which can be Google, but is also Facebook, is also Twitter, is also Snapchat. And so what Section 230 means is that these platforms are relieved of or immune of any kind of liability. So if I slander Dean Anderson on Twitter, I'm responsible, but Twitter is not. And so they really have allowed this to grow. Now, I want to diverge for just a second to point out to you the legislative intent of the Communications Decency Act. Remember, this was decided in 1996. Look at the optimism of Congress in adopting this. They say that the internet and other interactive computer service offer a forum for true diversity of political discourse, unique opportunities for cultural development, and a myriad of avenues for intellectual activity. Its policy is to preserve the vibrant and competitive free market that presently exists on the internet and other interactive computer services, unfettered by federal and state regulation. Well, anyone who's familiar with algorithms or seen The Social Dilemma, and if you haven't seen The Social Dilemma, you must, will see that unfortunately those pie in the sky dreams were not realized. Nevertheless, these social media platforms get to go on. And so as you can imagine, harms came from the social media platforms. One of the first harms was in 2006. And what happened in 2006 was that Lori Drew, the mother of Sarah Drew, learned that Megan Meyer, a fellow 13-year-old classmate, was saying salacious things about her daughter. In an effort to catch Megan Meyer, 47-year-old Lauren Drew created a fictitious 16-year-old Josh Evans on MySpace and started saying to Megan Meyer, I love you, you're beautiful, let's get together. And then one day, Josh Evans switched his tone, it was really Lori Drew, and said the world would be a better place without you. And Megan Meyer killed herself. And everyone was in awe, bad awe, not good awe, saying there ought to be a law. Because you see that the county in which she committed this crime could not charge her with any crimes on the book. And the federal government tried to charge her. They charged her with 4 counts of conspiracy. And the jury dismissed 3 and was deadlocked after 1. So here we had something horrific happen and no way to punish. And that's what got me started in saying maybe we need something separate for social media law because these wrongs cannot go unpunished. And so what I'd like to show you today is how courts punish social media harms. Let's start with one that happened this past summer. At least the Supreme Court decided this case this past summer. So this past summer, there was the case called Mahoney School District versus BL. BL has come out as Brandy Levy. We know that that's her name now. And what happened in that case was that Brandy Levy was a junior varsity cheerleader who tried out for the varsity cheerleading team. She did not make the team. And on a Saturday, sitting at a 7-Eleven, not near the school, she posted to her 230 Snapchat followers, fuck school, told you there'd be bad words, fuck softball, fuck cheerleading, fuck everything. Well, one of her 230 friends took a screenshot and showed it to the principal. The principal then dismissed her from school and told her she could never be on the varsity team and kicked her off the junior varsity team. Brandy's parents sued the school by saying that her First Amendment rights were violated. And all the cyberbullying institutions and advocacy groups were thrilled. This was going to be a chance for the Supreme Court to give us some regulations on cyberbullying. And don't forget, this happened at a time that most school was taking place off campus anyway because everyone was learning online. And so as much as everyone was excited about this, the result was less than astounding. In fact, what the court did in resolving this case was that they looked back to a 1970s case called Tinker versus Des Moines School District. And what happened in Tinker versus Des Moines School District is that some kids wanted to wear black armbands to protest the Vietnam War. And the court in that case said that the school tried to stop that. And the court said schools can regulate First Amendment speech so long as it has a substantial disruption on the school. And so coming back to Brandy Levy, the court found that this Snapchat did not have a substantial disruption on the school. So here we have a situation where the court has an opportunity to regulate harms and instead reaches back to precedent of 1972 and doesn't give us any norms on how to act, doesn't give us any guidance on how to regulate. In fact, kind of takes the approach the legislature took in 1996, that we want to make sure that everyone can have free speech and even if it's at the expense of some inappropriate speech. So the court in that case failed to recognize the greater degree of harm that occurs when there's many eyeballs on something. If Brittany had just passed a note, it might not have been as problematic. But when so many people see things like this, it becomes a problem. Another case happened with social media in the First Amendment. The First Amendment says Congress shall make no law abridging the freedom of speech and other things. What happened in that case was that North Carolina had a rule, and the rule said that sexual predators or sex offenders cannot, as part of their probation, engage in any website that children have access to. So Lester Packingham was a registered sex offender, and he had the good fortune of having a traffic ticket dismissed. And what happened was he, out of out of excitement, he posts, "Man, God is good. How about I got so much they dismissed the ticket before court even started? No fine, no court costs, no nothing. Praise be God. Wow, thanks Jesus." And he was then charged with violating his probation because he was on Facebook, which is something that children had access to. The court, in reaching its decision in this 2017 case, looked at the First Amendment, and they subject the statute to a content neutral evaluation. And the court found the statute was unconstitutional. But what's interesting about this case also is Justice Alito defined social media, the only time the Supreme Court's defined social media. And what Justice Alito said is that social media is very broad. It can include Facebook, it can include Amazon.com, it can include newspapers online, and even WebMD. And that each of those are protected space. So once again, we see this idea of unfettered freedom for the social media and a chance to regulate social media wrongs and a disregard of that. Defamation is one of the biggest problems when it comes to social media wrongs. Defamation, as you know, this is the teacher in me. I have to give the rule of law before I give my analysis. IRAC, people, IRAC. Okay. A false statement purporting to be fact, publication or communication of the statement to a third person, fault amounting to at least negligence, and damages or some harm caused by the person or entity who is the subject of the statement. And of course, we need malice if defaming a public person. So Courtney Love, who is in Hull and is Kurt Cobain's widow, posted many, many posts about Dawn Simonigoff, who was also a dress manufacturer. And basically, the dress designer gave Courtney Love this dress to borrow. Courtney did not want to return it. And then she basically defamed Dawn all over Twitter. This was the very first, this happened in 2014. It's the very first Twitter case, and it settled. So we didn't know how it would come out. But Courtney wasn't happy, obviously, with settling because she did it again to her attorney. And this time she said, and she said it, "I was fucking devastated when Rhonda Holmes of San Diego was bought off." Now, this is an attorney. And if attorneys are bought off, we know if someone believes that, that's an ability to run your business. And so that is defamation. But the court deciding the case said, you know what? This isn't really defamation. Nobody believes what's on Twitter. Same thing happened this year in Bauer versus Brinkman. Bauer versus Brinkman is a case where a landlord and a tenant were in a dispute. And the tenant had called the landlord a slumlord. The landlord sued the tenant, and the court said no cause of action. So time and time again, it's really hard to win in defamation because of what's now known as the Twitter defense and the Facebook defense. And the idea behind the Twitter defense and the Facebook defense is that nobody really believes what's on Twitter. Nobody really believes what's on Facebook. And that's because courts have basically, that has been their reasoning. I would argue that if Courtney Love's comments were published in a book or in a newspaper, we might have more of an argument for defamation. But because it's on Facebook, it doesn't get credibility. The first case to deal with threats on social media was Alanis versus United States. And what happened in Alanis versus United States was that Alanis was charged with threatening another. He was charged under 18 U.S.C. 875, whoever transmits an interstate or foreign commerce, any communication containing any threat to kidnap any person or any threat to injure the person of another shall be fined under this title or imprisoned not more than 5 years or both. So Alanis, an aspiring rap star, publishes his rap, and his rap says, I cannot rap. There's one way to love you, but 1,000 ways to kill you. And I'm not going to rest until your body is a mess, soaked in blood and dying from all little cuts. Hurry up and die, bitch. Now, if his ex-wife got this in the mail, that would be a threat, right? But the court here said, we don't know that this is a threat. In fact, what the court did in this case is they ruled very narrowly, the Supreme Court. And they basically said that this very statute doesn't have an intent element. And those of you who remember Morissette, if there's no intent element, it requires a minimum of reckless conduct. And the trial court, when deciding Alanis, did not evaluate whether he had reckless conduct. Now, the good news about the Alanis case is that it went back to the lower court, and then a lower appellate court said, of course, this was reckless. Of course, this was a threat. But the point I'm making once again is the Supreme Court, when faced with the opportunity to make a rule and give us some legal norms on how to act with social media, disregarded their opportunity, leaving us wondering. Sometimes courts do the right thing in terms of giving us rules. When juries are impaneled, one of the things that happens is a judge will say, you cannot look at social media, you cannot text. Well, Jonna didn't think about that. Jonna Lorraine sat on a jury for a doctor for the murder of his wife. And while on the jury, she texted 7,000 times. 7,000 times, I don't make it up. And she also looked at Twitter and she looked at Facebook. Now, people would say things like, oh, lucky you, you're stuck on it. And she'd say, I can't talk about it. They'd say, maybe make sure he's guilty. Her father said that to her. And she said, I'll tell you about it soon. And then he said, is he guilty? And she said, can't tell. Once the defendant found out that she had texted 7,000 times, the defendant brought it to the attention of the judge. And the trial judge said, you know what? Yeah, she texted. But all of this language suggests that she was keeping an open mind. No mistrial, sadly. Now, thank God we have a New York Court of Appeals because they said, come on, that's ridiculous. That this, you cannot text 7,000 times and not say it affects the outcome of the case. That at a minimum is distraction, if nothing more. And so now Newlander is waiting for his new trial. All right, next, what, now what's up? I don't know what's going on here. All right, social media and legal ethics. Someone's writing on my PowerPoint that I work so hard with my research assistant, Stephanie Geralt, who helped me so much. All right, this one will appeal to you attorneys and you future attorneys. Rule 8.4, Dean Gross knows, says that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Sitton was an attorney. He had a Facebook friend who he had never met. And the Facebook friend said, I hate my husband, I want to kill him. And here's what Mr. Sitton posted on Facebook. I am not making this up. If you want to kill him, then lure him into your house and claim he broke it with an intent to do bodily harm and that you feared for your life. Even with the new stand your ground law, the Castle Doctrine is a far safer basis for use of deadly force. That wasn't enough for Mr. Sitton. He then said, as a lawyer, I advise you to keep mum about this if you are remotely serious. Delete this thread and keep quiet. Your defense is that you are afraid for your life. Revenge or premeditation of any sort will be used against you at trial. The Tennessee court reviewing his case did find that he violated Rule 8.4, but they gave him 60 days suspension. Well, needless to say, the Tennessee Court of Appeals looked at that and said, we're giving you 4 years of suspension, 1 year real suspension, and 3 years probation. So there is hope that some people are recognizing social media wrongs. I mean, think about it truthfully. If this guy had only gotten 60 days, what does that say for deterrent value? What does that say to future attorneys? So at least we're getting something right. Now, to be sure, my theory is that we're not recognizing social media wrongs. But there are social media wrongs that courts are recognizing and that legislatures are recognizing. Legislatures have passed laws dealing with online threat, hacking and fraud, buying illegal products, posting videos of illegal activity or child pornography, cyberbullying, and cyberstalking. But if you look at these for just a minute, you'll say, wait a second, these are crimes anyway. They just added the word cyber to them. It's still fraud. It's still cyberstalking. Child pornography is still a wrong. So really what legislatures have done is they've taken the liberty of adding this idea of an internet. So every state, including Florida, great state of Florida, go Gators, and Louisiana and California have enacted cyberstalking laws. Let me just read you one provision. It says a person is guilty of cyberstalking if he or she, with intent to harass, intimidate, torment, or embarrass any other person, and under circumstances not constituting telephone harassment, makes an electronic communication to such other person or a third party. Using any lewd, lascivious, indecent, or obscene words, images, or language, or suggestions suggesting the commission of any lewd or lascivious act, or anonymously, repeatedly, whether or not conversation occurs, threatening to inflict injury. Now, this is stalking without the cyber. So once again, notice that there really has been very little creativity on the part of legislatures in enacting new laws to regulate new social harms. So basically what I'm saying to you today is that, and I think Dean Anderson said it best, is that technology is lagging behind the judiciary, that the laws that the courts are using are reaching way back into precedent that was decided pre-social media. Now, Justice Rehnquist said, the role of the judiciary is to keep the country abreast of the times while maintaining principles of precedent and stare decisis. And that's exactly what I think the court's doing. But in so doing, these courts are missing the mark of an ability to create laws and shape social norms as we head into the future. 50% of all children who are in school suffer or experience cyberbullying. Those of you who've been watching the news this past week know that Frances Hogan has accused Facebook of doing some real wrongs, including including promoting harassing language. I think one thing she said was that people tend to look at ugly or harassing language. Now, I'm not here today to suggest that the onus is on the social media sites. Many people are. That's what Congress is talking about today. And in fact, in order to do that, we need to amend Section 230. There have been no less than 14 proposals to try to amend Section 230, none of which have been approved. And in the interim, if we can't get Congress to enact it, we can at least get the courts to give us some guidance. Think about this. The Supreme Court missed the mark when it relied on Tinker. It could have easily created new law for student speech. Technology was beyond comprehension at the time Tinker was decided, and yet they disregarded that fact. When it comes to defamation, it's too easy to pass the buck to say, oh, that's just Twitter. Oh, that's just Snapchat. It's an opportunity for courts to be proactive and set some guidelines for us to follow. And the Alanis Court, the very first court to decide social media and threats, passed the buck by deciding that case on the narrowest of terms. I find this irresponsible. Thomas Jefferson said the laws and institutions must go hand in hand with the progress of the human mind. I suggest that that hasn't really happened here. But on the other hand, there's some hope here. Because what has happened is that the courts have relied on precedent and stare decisis. And in embracing precedent and stare decisis, they're basically embracing the fundamental principles of our American judicial process. And they're saying that the laws work, the courts work, precedent works. We can mold new cases on previously decided case law. And I'm going to argue that that's a good thing. And I'm going to say to you, the students, that that's a great thing. And that's why we make you brief cases. And that's why we make you understand the reasoning. And that's why we give you hypotheticals. Because as you go on to practice, you're going to get these new, never before encountered ideas, and you're stuck with the legal handcuffs of previously decided case law. So I submit to you in conclusion that although it's unfortunate that we're losing the opportunity to regulate social media through courts, and the legislatures have kind of dropped the ball in acting, as has Congress, that the one good takeaway of this is that our judicial system is doing what it's intended to do, which is relying on cases they've decided before in reaching its new conclusions. So I thank you for that, and I'm happy to take questions. Thank you. All right, so thank you. Thank you. Thank you. Everybody should have colleagues like I have. It's nothing better than that. Before we take questions, I want to say that welcome people on Zoom. And hi, Mom. And also, we have a microphone over there. So again, I mentioned Stephanie. She's been my research assistant for all this, so she's been really helpful. Fellow Gator, and she's going to read the questions if you post them in the chat. I think we have one question in the chat we'll do first, and then I'll take questions from the audience. No, we don't have any questions? All right, so does anyone have a question? Someone has a question. Oh, Jason, thank you.
I have a clarifying question and then a substantive question. So clarifying question on some of your slides, profanity was redacted and some weren't. And so my question is, was the original posting redacted, or did you choose to redact them? And if so, why some words and not others? And my substantive question is that some words were redacted and you yet vocally said those words. And as the rise of social media is now transitioning to video, have you seen any difference in legislative regulation or the judiciary treating spoken profanity, bullying as different than written words?
All right, so two things. So the actual tweets and Snapchats had the actual words, but we couldn't find the actuals anymore. So we took it from newspaper clippings when we did our post, our slides, and they didn't put in. But I know for a fact that Courtney Love said fuck, and I know for a fact that the cheerleaders, well, shocking. And I know for a fact that Brandy Levy did too. And then as regarding, it's interesting that you say that. I wrote an article a long time ago called The Death of Slander. And the idea was that there's written and there's spoken, but when it comes to Twitter, let's say, people kind of speak what they're thinking. It's not that premeditative, reflective kind of thought that people are used to, which is what we really kind of try to protect defamation for. So to answer your question, I haven't seen a difference in response to spoken versus written, but what I have seen is a trend to say that those lines are blurred now a little bit more. I don't think with pornography, I mean, I think, you can describe it in writing and then you can see it, and I think that's a different category, but other than that, I think it's true. Hi. All right, so there's nothing that I know of pending, and keep in mind that since social media came into being, there's only been 2 cases that the Supreme Court has done. One is the Alanis case and one is the Brandy Levy case. I don't know of any. I'm sure there are some on the lower courts. Remind me of your second question. I know the answer, but I don't remember what you asked. Yes. All right, so the question is, of the 14 proposals, are there any that have legs that could? So the answer is no, those are all gone. Now, what's happening right now is Congress is holding hearings, right? So going back to the last election, one of then President Trump's kind of cause célèbre was to get rid of Section 230. The problem with getting rid of Section 230 is kind of a business one, if you will. It's not so much a First Amendment, but when you think about it, and this is kind of one of the issues before Congress now, the cost of not using algorithms and reading every single tweet, every single post to make sure it's not harmful or it's not defamatory is enormous. And it will have a chilling effect on social media platforms surviving. And that's kind of was the impetus, actually. So Section 230 was enacted because of a lawsuit against it was an AOL chat room. And so the two congressmen said, like, well, no one will ever get in the business of social media. I do think that that the legislature and Congress, after this whole hearing, are going to try and come up with some regulatory measures. But I don't know, listen, they can't pass anything, so who knows what's going to happen. But I don't know. I don't know how to fix it. I mean, maybe I should, but I don't know. And I don't know that they know how to fix it. But good question. Thank you.
Election, I guess the influences of social media on the elections past year, 2016 and 2020. Social media companies have been enacting their own regulations and taking out hate speech, taking out politicized speech, and they've been before Congress. And think about this now in light of knowing about Section 230. Do you think that there should be a bigger onus on the social media companies to regulate themselves with maybe, say, like, Congress making regulations to say you should implement these regulations in your own sphere, however that works, in more social media companies? Because Amazon social media, according to the
Right.
WebMD is
Mhm.
social media, which doesn't make sense to me. And maybe the same kind of regulations that would apply to the traditional, like a Facebook, MySpace, wouldn't really work with an Amazon, the WebMD. So.
No, that's a good question. So, you're right that the social media platforms are the gatekeeper of the content, right? So they really are the ones in the best position to regulate content. And, to be honest, legislators are not in the thick of kind of the technology involved, and it's kind of complicated to understand algorithms and all of that. So I agree with you that the onus is on them. One of the things Frances Hogan said was that there was a kind of regulatory body to regulate the speech during the campaign, and then it was disbanded once the campaign was over. I do agree with you. I think they're in the best position, but short of being told that they have to facilitate it, I mean, one thing we could hope for, and I don't know that this would ever happen, is that, people could kind of march with their pocketbook, so to speak, meaning don't use the social media platforms that promote, harm. Like, stop using Instagram because it's causing kids to, feel body shame. But, good luck stopping to use Instagram. That's the so that, I think, good question though. Stephanie?
Before you answer, repeat the questions.
Oh, okay, thank you. Okay, I will repeat the question. Sorry. Yes, question.
Do you see any distinction in the legislature or judiciary on the actual speaker? Because
Alanis, yeah.
So Alanis had an account that was associated with an artistic platform that might be interpreted very differently than it was personally. I'm wondering if there's any distinction about who's actually talking.
So that's a really good question too. The question is whether the speaker, whether they're a public person, whether they're in the forum of Alanis was a rapper, whether that's made any difference in what they are, their content. I think what happened with Alanis was that they basically said that Alanis's defense was, I'm a rapper and these are my lyrics. That was how he tried to get around it. The court didn't give a lot of credit to that. That was more of a fact situation. Courtney Love was treated no differently than the landlord-tenant situation. So I don't think that they look at who the speaker is as much as what the speaker says. Follow up?
And then forensically, how would we know who actually typed the thing?
Well, as we say in the classroom, that's a problem of proof. So I don't know, you can, I mean, that I can't answer. I can tell you Courtney Love owned up to all of it. So, I have not seen anyone saying someone else typed on my behalf. But what I have seen quite often is people being unable to sue because of an anonymous tip. One last thing I'll say about that. Speaking about Megan Meyer, Lori Drew did this fictitious MySpace as Josh Evans, and they found her. So, yes, question.
Okay, is this good?
Yeah, good.
So we have a question from Zoom that says, does Professor Tenzer really think the, fuck school case should have been the one to change the law? That one seemed very tinker, and would she really want to have school regulate expressions like that?
Okay, so the question, oh, you said the question, I could hear.
I think
I'm of two minds. On the one hand, I am a proponent of free speech, but on the other hand, I guess I want to see someone do something. I think that cyberbullying is out of control. I think that you can distinguish what BL did in some ways because she really wasn't bullying anyone by saying, fuck the school. One of the things I will tell you is that there have been certain instances where people have posted, there's a case where a kid was at a Jack in the Box and he posted, I hate this teacher and I'm going to kick her ass. And he was punished. But I think that given that the Supreme Court so rarely takes these kinds of cases, that it really would have been able to give some guidance 40 years after the last case on school regulating school speech. So I think they could have drawn maybe not specific parameters, but I think they could have narrowed the parameters. Yes. Hi. So what standard, what do you mean by that, Andy? What do you mean? Oh, well, I think, okay, the question is what kind of standards, kind of like content neutral standard, what kind of standards did they impose? And that's a great question from a student I've seen on Zoom only. It's good to see you in person. Actually, I did see a little bit. Anyway, so I think the test has to vary depending on the wrong, right? So I think that if you regulate a prisoner or a sex offender on speech, that is content neutral. And I think that when you're regulating defamation, right, then you have to go by the standards of defamation. What I would like to see, especially vis-a-vis defamation, is not this deference to, oh, it's just social media. Like we can't say, oh, it's just social media anymore. And I think, and thank you for kind of kicking this off, but if I have to make some kind of passionate plea, my passionate plea is the idea that we can't just dismiss social media. It's here to stay and it's spiraling out of control. And I will not, I'm not going to talk about the misinformation aspect of it, but it is kind of, we're in a position that we were never in pre-social media. And so to the extent that courts are not doing, to the extent that legislatures aren't doing anything, then the courts really could step in. All right, we're going to take two more questions because I know people have to go. One more question because people have to go to their next class.
Okay. In your opinion, where is the line between judicial regulation of social media and censorship, and how do we not cross it?
Oh, okay, so what's the line between? That's an interesting question. That's an interesting question that the legislatures can't figure out, and that's the problem with regulating and changing Section 230, because there is what is the difference is the problem, but it's analogous to yelling fire in a crowded theater. I think if it causes identifiable harm, that we can say it's wrong. But to do that, it has to be on a fact by fact basis. I don't think it can be a global legislative ruling, because what will happen then is you will infringe on free speech. So I know people have to get to class. I don't want to keep anyone anymore. Oh, wait, one more question. One more, last one. Go, Audrey.
So
Okay. to say that, well, if you allow certain verifiably false information, know that there's active bullying going on, you, AOL, and you, Facebook, won't it give more incentive to Facebook to come up with better algorithms? So that's a great question. So the question is, it's a hypothetical from my dear friend and former colleague. It says that if we change section 230 to allow, to require them to verify false information, that there's active cyberbullying. What was the second part of the question? Oh yeah, won't that promote more algorithms? Right. So in algorithms, basically what algorithms do is they find out what you're looking at and what you eyeball, they say, and they tend to show you content that's very similar. I don't have a problem with that if the algorithms are going to show neutral content and not harmful content. So if there's a way, everyone knows, you go on Instagram. I mean, heck, I was talking to someone about a fireplace and then I got fireplace things on my phone. I was just talking about it, So I think that getting rid of the algorithms would be best, right? But then the problem is then advertisers lose their advertising base. And that's what really drives the algorithms. But I do agree with you that you could put the onus on those companies. And in so doing, they're going to have to figure out, they're strong enough that they can make money, right? And so now they have to figure out how to make it work with that. So, all right. Thank you all so much. Thank you. Thank you. Thanks. Thank you. Thanks. And I want to thank my friends and my former students too for being here. So thank you so much. Thanks. And to Corinne.